Good morning. This is time and place for the planning hearing officers' cases for June 2nd, 2010. My name is Laura Stotler, and I will be conducting the hearing as hearing officer for the first item. Today we have 3 cases on the agenda. One of the cases is a variance under the provisions of Title 30, Chapter 30.43 of the Glendale Municipal Code. A variance shall be granted if 4 required findings are present. First, that the strict application of the ordinance would result in practical difficulties or unnecessary hardship inconsistent with the general purposes and intent of the ordinance. 2, that there are exceptional circumstances or conditions applicable to the property involved or to the intended use or development of the property that do not apply generally to other property in the same zone or neighborhood. 3, that the granting of the variance will not be materially detrimental to the public welfare or injurious to the property or improvements in such zone or neighborhood in which the property is located. And 4, that the granting of the variance will not be contrary to the objectives of this ordinance. If the evidence presented in the application and at the hearing meets the criteria just described, the public hearing officer can either approve or impose conditions for approval on the case in question. If the findings of fact are not evident, then the request will be denied. Notification of this hearing was accomplished by the use of public notices, which were mailed to property owners located within 500 feet of the subject property, physically posted on the site in question, and placed in the local newspaper. Hearings will proceed as follows. I'll read a description of the application request. I'll read the reports received from other city departments and other letters or communications from interested parties. The case planner will make a brief overview of the case, give analysis, and make a recommendation. The applicant will then be asked to come forward stating both name and address, and will be asked to present the case within a 15-minute time limit. Others in support of or in opposition to the application and any other interested parties will be asked to come forward to speak, again clearly stating both name and address, and they will have a 3-minute time limit. Lastly, the applicant will be given the opportunity to make closing comments, if desired, in response to testimonies given by preceding speakers with a 5-minute time limit. The hearing will be closed and the case taken under submission. After the hearing, the decision will be prepared in writing, will be in the form of a letter sent to the applicant and to all persons who responded to the public notice, either by speaking at this hearing or by submitting written responses, and who have provided their name and mailing address. The date of the decision will be the date appearing on the letter. That would not be today's date, but the date on the letter. Under the appeals provision of Title 30, Chapter 30.62 of the Glendale Municipal Code, the decision may be appealed to the Planning Commission with 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures on the procedures from Building and Safety Section Permit Services Center, which is located on the same floor of this building. If you wish to speak, please write your name and address on one of the speaker's forms, which has been provided by the front door and submitted to our planning assistant. And those are the green forms that look like this. I would also like to inform everyone that the official proceedings of the public hearing officers are recorded on tape and are part of the public record. So for the first case we have, this is a continuation. This is case PVAR 2009-041, located at 1244 Berkeley Drive. The applicant is V. Barbieri, the owner is J. Barbieri, and the case planner is Dennis Joe. This is an application for standards variance to construct a 2-story, 953-square-foot addition to an existing 1,170-square-foot single-family residence with a legally non-conforming 4-foot interior setback located at 1244 Berkeley Drive within the R1R Restricted Residential Zone, Floor Area District 3, described as Lot A, Parcel Map 1477. Since this is a continued case and we already heard all the comments that have been received from other departments, I would just like to ask the case planner to give us an update.
Good morning. Thank you, Planning Hearing Officer. Since January 20th of this year, the applicant has reduced the size of the addition for the 2-story addition to 849 square feet. Additionally, has set back the second floor of the addition to conform with the front yard setbacks. Should I proceed with my presentation?
Sure.
Thank you. I'm going to approach the board. To briefly kind of go the zoning for this property is R1R, Floor A, District 3. The site is approximately 5,300 square feet in size. It's developed with an existing one-story single-family home that's approximately 1,200 square feet, as you can see in this picture right here. The property is irregular in shape and has a subtle incline upwards from the front to the rear portions of the lot. The subject property, once again, is developed with a one-story single-family home. It has a front setback of 15 feet from the front property line along Berkeley Drive. It's also configured with a 4-foot interior setback from the north and a 11-foot setback from the east and a 20-foot setback from the south. Well, the project proposes the 849 square foot addition, about 376 square feet for the second level, which was recently reduced from the original request for 376 square feet for the second, and it will have a 473 square foot for the first level. The addition will only take place at the southern portions of the property and will not extend over or modify the existing portions of the single-family home as I'm circling over here. So this area will not be affected, and the project will only take place on the southern portions of the lot. The new setback for this new portions of the addition will be 5 feet. And because the overall height will extend to 28 feet and 3 inches, the zoning code's standards for the interior setbacks will be 5 feet, since it's going to be 20 feet, greater than 20 feet, less than 30 feet. So therefore, we have an affected setback at existing portions of 4 feet, which the code now counts out to be, or requires to be 5 feet. However, once again, this interior setback is proposed not to be modified. However, it's only proposed to continually to exist. Staff analysis believes that there is exceptional circumstances of the lot. Because of this 4-foot setback already exists, and the proposed second-story addition will be approximately 31 feet and 9 inches away from this affected setback, that it does not propose, basically it doesn't propose anything over here, and it's only requested to maintain this existing 4-foot setback. In this area, the floor plans demonstrate that this will be it will maintain as a living room, a dining room, and a kitchen. Staff believes that there will be practical difficulties and unnecessary hardships as in order to comply with the new 5-foot interior setback and the existing portions, it would have to demolish about approximately 1 foot along this area. This existing portion right here will be approximately about 45 feet and 7 inches in length, which would cause a hardship as far as engineering and reconstructing this whole area just to reduce it by 1 foot. And in order to accomplish that, staff believes the overall integrity of the building will be compromised. But overall, staff does recommend approval for this application, as it will not be contrary to the objective of the ordinance. And lastly, I would like to close my presentation. Staff did once again receive a letter from the Adams Hill Neighborhood Association in opposition to this project in regards to the interior setback. And also they have addressed its concerns to the massing and scale of this project, as they believe it's going to be large. But once again, I just want to reiterate that there will be a required DRB application, which will address the site planning, the mass and scale, and the overall design. And today we'll only be reviewing for the planning hearing officer to review its interior setbacks and not the design and massing and scale. This concludes my presentation, and the applicant and myself are available for questions.
I do have a question along that 1 foot where it is right now it only has a 4-foot setback, and if they add a second story, they would have to have a 5-foot to comply with the code. What is the neighboring use? Is that a driveway that's along that side of the property?
That's correct. There's an existing driveway that goes along here, and there's an existing single-family home. That's absolutely correct.
Okay.
As is indicated on this photograph right here.
And then where there is the addition by the garage, what's the use on the neighboring property right adjacent?
Although it's zoned as a single-family residence, it is a vacant lot which is not being utilized as a residence.
Okay. And then I do want to clarify, too, that I know there's been construction on the site that is under a separate permit, correct?
That's correct. There is for the garage, to update the garage and a kitchen addition at the rear.
And so that's not part of this proposal at all, correct?
That is not part of this project, as it was previously approved over the counter prior to this application.
And does the redesign allow for proper separation between the addition and the garage, so we don't have to consider the garage as part of the height of the building?
That's correct. It is considered as a detached structure.
Okay. With that, I have no further questions for staff. I'd like to call forward the applicant, Vicky Barbieri.
Good morning.
Morning.
My name is Vicky Barbieri. I'm the architect and applicant for the project. I hear all the explanation in the project in between Dennis and you, and it's absolutely complete. I think it's totally clear what we are asking for. I think to demolish all along the house, existing house 1 foot is something more than a hardship. And my son, who is the owner of the property, and I will respectfully request to accept our proposal of the addition to the south with a existing 4-foot setback.
Okay.
I don't have nothing else to add unless you would like to ask me questions.
The only question I have is I see on your plan that you have posts that look like it's going to be for a fence. I just want to let you know that we can't have fencing in the front setbacks, so I just want to make sure you're aware of that. And if we put a condition of approval on to that effect, would you have any opposition to that?
No, I wouldn't.
Okay. And then also, we had a concern for fire department access to the back portion. If we put on a condition that would require you just to make sure that you design that to the satisfaction of the fire department, would you have an opposition to that?
Yes, we've been talking to Dennis about that, and I said, yes, we definitely will accept, and we will have to discuss with the fire department what they request, and
Okay.
definitely we will comply with the fire department.
Okay. I have no further questions. Is there anybody else, or do you have any further comments you'd like to make?
I don't. I just
Okay.
want the approval.
Is there anybody else in the audience? I don't have any other speakers' cards, but is there anybody else who would like to speak on this matter? Okay, I don't see anybody. Thank you.
Thank you.
And then
Thank you very much.
I just want to acknowledge that I did receive and read a letter that was mentioned by Dennis Joe from the Adams Hill Neighborhood Association. So I just want to acknowledge that I did receive it. I did read it as Dennis had mentioned it earlier. Well, based on the information I've received, I will take this project under submission, and then I will call the next hearing officer. I believe we have two other cases that are following. So let me go see if we can get them.
right, good morning. This is the time and place for the second item on today's zoning hearing officer hearing for June 2nd, 2010. My name is Brad Collin. I'll be conducting this hearing as a hearing officer. I'll be hearing case number PVAR 2009-028, which is located at 3352 Mary Street. The relevant exhibits are posted on the panels located directly behind me. If you wish to speak, please write your name and address on one of the speaker forms, which have been provided by the front door, and submit it to our planning assistant. I would also like to inform everyone that the official proceedings of the zoning hearing officer's hearing are recorded on tape as part of the public record. Notification of this hearing was accomplished by the use of public notices, which were mailed to property owners located within 500 feet of the subject property, physically posted on the site in question, and placed in the local newspaper. This particular case, as mentioned, is a variance. There are 4 findings that are required to be met for a variance, and I'll run through those findings real quickly. The first is that the strict application of the ordinance will result in practical difficulties or unnecessary hardship inconsistent with the general purposes and intent of the ordinance. The second, that there are exceptional circumstances or conditions applicable to the property involved or to the intended use of the development of the property that do not apply generally to other property in the same zone or neighborhood. Third, that the granting of the variance will not be materially detrimental to the public welfare or injures to the property or improvements in such zone or neighborhood in which the property is located. And fourth, that the granting of the variance will not be contrary to the objectives of the ordinance. If the evidence presented in the application and at this hearing meets the criteria just described, then the zoning hearing officer can either approve, impose conditions for the approval on the case in question. If the findings of fact are not evident, then the case will be denied. The hearing will proceed as follows. The case planner will make a brief overview of the case, give an analysis, and make a recommendation. I'll go over reports received from other departments as well as letters that we have received from surrounding neighbors. The applicant will then be asked to come forward, stating both name and address, will be asked to present their case within a 15-minute time limit, and it's important to address how the project complies with the required 4 findings. Others in support or opposition to the application interested parties will then follow, again stating name and address clearly for the record, and will be allowed a 3-minute time period. Lastly, the applicant will be given an opportunity, if necessary, to make any closing remarks or comments in response to the testimonies received by the previous speakers. The hearing will then be closed at that time. So, as mentioned, we're looking at case number PVAR 2009-028, located at 3352 Mary Street. And Mr. Baxter, would you like to give us a brief summary, please?
Yes, sir. Mr. Collins, here's a photographic survey of the house. And the case is located behind you on the panel, as well as on the overhead screens and on that television screen here behind you. The applicant is here to legalize a 373 square foot addition at the rear of the house. It's being used for a family room and a laundry room. You can see here in the floor plans. The Neighborhood Services Department has a code enforcement case against this property, and so the applicant is responding to that. Now, the case has a previous, or this project has a previous variance that was approved back in 1981 for an addition that they wanted to add without providing the parking, and that was granted at a building permit, and they built a carport instead of a garage at the time, so that was all taken care of. But they had a patio that was open, that was enclosed, and that's part of what we're looking at. Now, the applicants has stated, and we have some letters from neighborhood persons, I think 4 letters from neighbors, who said that the addition was done prior to this owner, which seems to be consistent with what the owner has told us. Now, when we look at some of the information here, the staff notice that the lot size is smaller. That's one of the problems. There's just no location to put the garage. And when you do a survey, and we showed a survey that the applicant submitted that shows that the overall dimensions of the lot, as well as the lot square footage, are smaller than the vast majority of the lots in this neighborhood, in this subdivision. So there is kind of a land use hardship and a uniqueness that we felt could qualify this home for addition without the carport, which seems to be working at this time, and they've had that addition for a number of years. There really isn't much more. It's a pretty simple little case. It's pretty straightforward. If you have any questions, I'll be glad to answer them.
Quick couple questions and clarifications. So there's basically 2 additions that are being legalized.
Correct.
Can you point
Yes.
those out?
Yes, sir. It'll be this one and this one. This was a patio that was an open-to-the-sky patio when it was approved for a little room addition right here. And then this little piece back here is a laundry room. Right. So this has been enclosed. It's a family room that you can see here. And there's the laundry room, which was, you see in the photographs, looks like it was added.
And
It's a little place for the laundry.
in relationship to all other code requirements other than the parking, they're in compliance with?
Yes, yeah, they meet, well, as it is right now, since they have this variance, back in 1981, this is what was built minus this and this. So as far as setbacks, floor area ratios, height, landscaping, lot coverage, they do meet the. But this setback here, they don't meet code, and they don't meet a code over here. But that's on the variance and on the building permit.
Right.
That's what was stamped off and approved. Building and Safety signed off on it 20 years ago, over 20 years ago.
When the house was constructed?
No, the house was
The addition.
constructed in 49, when that addition was constructed. So there was this little addition right here. This triggered the first variance.
Right, I understand that.
The house overall was built in 49. And then they did this, which triggered a garage. They required a variance.
Right.
They built a carport instead, the variance approved it. And they got approval, and in 81 to what is today, it's almost 30 years, I guess, they've had this built like that. Then somewhere along the line, they came in and bootlegged this in, closed it, and made a floor area for the, like a living room type thing, dining room, and then this little laundry room here.
Okay.
That's pretty much what it's like.
Thank you very much.
Yeah, and you can see in the overhead, gives you kind of an overview. The properties over here are city and county properties, and you can see the house in this white area, in the white area back here. Those 2 areas are the bootlegged areas.
Thank you, Mr. Webster. At this point, I'm going to open up the public hearing. Actually, hold on. Let me do one thing real quick. As mentioned, we have 4 letters that staff has given us of support from surrounding neighbors. We have no comments from any of the related departments that have reviewed the case. And now I'll open the public hearing and ask for the applicant, which is Orbel Kashishian. Did I pronounce that right? Yes. Public hearing is now open. Please state your name and address for the record.
Hi, my name is Orbel Kashishian. I live on 1916 East Chevy Chase in Glendale. For past year, for over a year, I've been going back and forth with Mr. Baxter for this project, and I hope we can find a way to put an end to this problem today. I have my findings ready. If you let me, I'm going to go over it.
Go ahead.
Providing two-car garage with an inner dimension of 20 feet by 20 feet would be impossible, and it would result in practical difficulties and unnecessary hardship for the owner. Because one, the lot size, as you can see on the map, on the vicinity map, is way smaller than the rest of the properties on Mary Street. It's almost half the size of the rest of properties. And two, there is not enough space for the carport to be extended out on westerly side of the property line to feed two cars. There are exceptional conditions applicable to this property that does not apply to other properties on the same street. Compliance with the code is simply impossible because the lot is one of the two smallest parcels on Mary Street. And other than that, the owner does not have the financing available to tear down or change anything on the building. He bought the house as it is right now, the same condition. There wasn't any change or additions or alteration done to the house. And before he bought it, he rented it for about 7 years. And he wasn't aware of what's going on with the property. The approval of a variance to allow legalization of existing enclosed patio and laundry room while keeping one-car carport will not be harmful to the public welfare. Current situation is over 2 decades old and does not create any problem for street trafficking. No negative testimonies or complaints have been received from surrounding neighbors over the past 20 years or more. The existing carport will continue to serve the single-family dwelling only. Approval of variance will not materially affect the health and safety of general public. The purpose of code is to provide and guarantee health of general public by minimizing traffic issues. Once again, in order to comply with the code, a 20 feet by 20 feet two-car garage is needed. But due to lack of space, constructing a two-car garage is impossible. However, there is enough space on the property to park 2 cars back to back. We have more than enough room in front of the carport, so over 20 feet space, so I'm sure they can fit both cars on the site. And they have room on Mary Street and New York. So that's how they've been doing it for past 15, 17 years. Other than that, I don't have anything else to say. If you have questions, I can answer your questions.
Couple of questions. Can you tell me again how long the owners have owned the property?
About 17 years. 10 years, but 6 years they rented it, and 10 years they
So
bought
they
it 10
rented it
years
for
ago.
6 years and then owned it for the last 10.
10, yeah.
Okay, thank you.
Thank you.
Next, I have Barkas Alaverdian. Please state your name and address for the record.
Yes, good morning. My name is Varkes Alaverdian, residence of 335 Mary Street, Lacra Central, Glendale, whatever, what is saying.
Go ahead, I'm sorry.
Mr. Commissioner, I'm here today to try to resolve my home situation. On September 1994, me and my wife and 2 children moved to 335 Mary Street in Glendale as a tenant. We stood as a tenants until January 2000. At that time, the houses went into foreclosure, and I had the choice of moving out or purchasing the property. I decided to purchase the property. The property is the same as when it was purchased. I have not added to demolish anything out. I have those LA County City case. It shows change of ownership occurring May 23, 2000. And a paper of the bank, which I purchased the loan on April 2000. When I became an owner. Today, after 10 years gone by, I am in a very unusual situation with the city of Glendale. The city inspector noticed a laundry room and the enclosed deck that was added God knows when, and I am trying in everything I can to cooperate with the city to resolve this situation. Example, I have hired an engineer to help me with the drawing of my house, so I can complete what was not done 20 years ago with the previous owner. But unfortunately, the planning department, rather than help us get through this situation, has been non-cooperative up to now. I am here simply to do what's necessary to satisfy the city and end this long and stressful process. This house was modified in 1981. I have here, I pull it from the city permit 1981. According to city records, my question to this committee is, where was the city inspector at that time to notice that? Why did the city allow this problem to linger almost 29 years and making me to pay for things that I am not liable for? Another example is March 10, 2003, case number 0300022242. City requested to remove my chain link fence and replace it with brick wall. I have done per city request and spent a few $1,000s, and I received a letter from the city on July 23, 2003 to let me know I have done a good job. I think you have those papers, include the pictures. If you don't, I have the copy. I can pass it to you.
Have them in a file.
Okay. That's fine.
On March 25, 2009, Neighborhood Services and Code Complaints, case number 090002320. City asked me to correct 3 things. I have corrected 2, and the only issue is a laundry room and deck enclosure without permit. I am here with my engineers trying to overcome the situation, but it seems like as I try to take care of that matter, planning wants something else, so I am very confused about all this, and you are aware of the bad economy. Since last year, my full-time job is now a part-time job. Only at considering my wife and mother-in-law are disabled really makes this a stressful situation due to the facts that I no longer have a full-time job. I have disability form from this Social Security for my wife. I mean, disabled is not disabled for doing nothing, but doing littling things, taking care of the home, cooking, and taking my granddaughter, 16 months old. You are my home city. I pay all my taxes, and I am asking you to try and help me finish this project to help me live in the house I purchased. I am here to cooperate with the city and hope we can come to reasonable terms. We all know that we are simply talking about the house that was built over 16 years ago. This is what I'm writing here, but I'm going to add this a little bit verbally too. Me and my wife immigrated in this country back to very, very usual day, 4th of July 1980, which house was modified 1981. I born 1948, which a house built on 1949. All this year I worked very hard, saved a little bit money to purchase these houses. This is only hope we have, me and my wife, and this is our future to pass to our kids or to the daughter I have. So I hope the city consider about this, not throw me all this hard work shift to keeping this house put down the drain, and lose all those part of the houses. We like all the piece part of these houses. Well, then we moved in as a tenant. Nobody's, when you are tenant, you don't know, you don't care about which part is legal, which part is not legal. You live there. Then when I became up as the owner, we was very happy for all these years until we came up to this situation. I hope city understand me, you, Mr. Commissioner, with all respect, I hope you understand our situation, especially my financially. Even when right now I'm standing here, it costs for me over $8,000 because they asked me, Mr. Boxer, I need to binding property line survey. I have to spend over $800 for that. For planning, I paid for all those recording to be here. It's over. Believe it or not, I borrow all those money from my son-in-law sitting here, from my friends. I don't know how I'm going to pay back to them, but I hope you consider all this.
All right, thank you very much.
My family make me happy.
I understand. Thank you very much.
If you have any question, I'd be happy to answer.
Not as of yet. Thank you.
Thank you so much.
Next, I have Tim Morello.
My name's Tim Orillo. I live at 3729 Santa Carlotta. This is my father-in-law's home. I've been going there for over 7 years. I haven't seen any changes in the property. I've had conversations with my wife and family. As far as I know, all these changes have been done before they moved into the property. As far as parking goes, there's never been a problem. We fit 2 cars in that driveway all the time. There's never been an issue. As far as safety is concerned, I go over there. I've spent many occasions in that room and never felt unsafe. I let my daughter go over there every day. I feel that's very safe for her. She uses that room and enjoys it. As far as, I know Mr. Oliverian's very hardworking. He's a citizen of this country, and he has strived to, improve his life for his family. And I just think it would be a great hardship to make him, have to change anything. And I ask that you please show him some mercy and let him leave his property the way it is.
All right, thank you.
Thank you.
The last speaker card I have is for Ruben Ovanesporin.
Yes.
Please state your name and address.
Good morning. My name is Ruben Ovanespur. I live in La Cañada, 4907 Angeles Crest Circle since 1983. I have been friends with Mr. and Mrs. Alaverdian for a very long time. I know them when they were renting this house. And I know them when they decided to purchase this house from a foreclosure. I know for a fact they never added, altered, or did anything to this house. Since all the time that I've been going there and coming, I have not seen anything whatsoever in there. They both are very, very honest people. They're very decent people. I would really like to see the city of Glendale try to help them and resolve this issue, because they have made every effort to comply with whatever issue the city is requesting from them. They have hired the engineer, they draw plans, and they're trying to cooperate with the city in any way that they can. We have gone to their house many, many times throughout all these years, and we park our cars there, and we always felt very safe in there. We never have any issues as far as safety inside the house or anything whatsoever. I would like to ask the city and to try to help them whatever they can to solve this issue.
Okay. Thank you very much.
Thank you very much.
I had one question for the owner, Mr. Alibertian. From what I'm understanding, you said you moved into the property in 1974.
1994.
When did you start renting it?
1994.
And then in 2000, you purchased the property through foreclosure.
The houses went to foreclosure, and 2000 I purchased it.
Okay. And then when you moved in 1994, what was the condition at the back of the house?
Exactly the same as you see now,
Okay.
with enclosure deck and the laundry room, and there was the fence outside, which I changed by the city requested to
Right.
break wall, and I did that. I really be painting inside, changing my kitchen closet, make upgraded. Those things I did. Change the carpet, all those things when I purchased.
Right. Okay, one other question. In looking at the plan for the property and the floor plan for the house, is there anywhere else that you could potentially move your washer and dryer, like inside?
No, there is none. There is none. Because the original plan, it's a 2-bedroom. One is very small, but built on 1949. The third one, added on 1981, it's a regular size room, you know. That's nothing I can cut off from room and add them to that. Besides, my laundry room, it's way from the, at least, I think it's 12 feet away from the property line. And it's hurt nobody. There is nothing is wrong to hurt that people. Because next side, if you see, it's a open property which is belong to County Los Angeles and City of Glendale. Well, I know forever nothing is going to be there because there is a sewer pipe passing through in the middle of that property. There is an easement and nothing is going to be. And my rear side is very far. It's only the garage back rear wall is facing to my property line, and nothing else can hurt my laundry room to them. If there was, for 29 years, no, it's not going to be stand there for that laundry room. I'm sure anybody's going to complain for that, but it's not hurt anyone. At least I can only tell I request it. By approval, what I'm going to do, I have to borrow money and make one-piece building, make the stucco, make the nice looking from outside to make one-piece building.
Okay. As a point of clarification, the finding or you're mentioning that financial hardship is not something that we can consider as a hardship as it relates to the 4 findings. Just as a point of clarification, that you can't claim that as a hardship, because that's something that everybody can claim. Just as a point of clarification.
Okay.
Okay. Thank you very much. One question for staff. Go ahead and have a seat. Thank you.
Thank you.
A clarification again. The previous variance was from 1981, which is where the bedroom was added at the back and the carport. Is that correct? Okay.
And there was a patio, an open patio added at
Adjacent to the new bedroom.
that patio closed now.
I'm sorry, it's a 2-bedroom and open deck or patio.
I'm sorry. I understand. I'm going to close the public hearing at this point.
Yes, sir. As I mentioned here, sir, let me just go over here. So, at the time, this was the bedroom that they wanted to add
In conjunction with the carport.
with that carport. This was a patio open to the sky,
Right.
as I understood it. They received a permit for this, and built it, and final. And then the patio at some point, and this laundry room at some point was, this was enclosed and this was added. At some point, doesn't seem like anyone knows what that is. Okay. I think the entire house with the addition is 1,303 square feet, so it's 1,300 square foot house with the addition.
Okay. Mr. Baxter, can you read through what you're recommending as the conditions of approval?
It's not on? Oh, okay, well, sorry about that. I'm sorry. The staff believes that there is sufficient evidence to grant this variance request, and so that's what we wrote here in our staff report. And we went through and detailed through our 4 findings and to support that request for an approval. And then the conditions of approval that follow, there's 6 of them that we have listed here. Condition 1 and Condition 2, actually, pretty much all of them are the standard boilerplate conditions. So number 1 is that the development shall be in substantial accord with the plans submitted with this application. So that's a standard 1 that we look at. Number 2 is that all necessary permits shall be obtained from the Building and Safety Division, etc., to comply with codes. Actually, I was going to say, Mr. Collins, we ought to mention to the applicant that when you go to plan, if this project were to be approved, and I don't know, you would need to go to plan check, meet all the building code requirements. So there's going to be a cost involved with that. You have to understand. I just thought that needs to be clarified. Even without planning, even with the planning approval, you still have to go to building, get permits. Number 3 is the design review board requirement of either an approval or an exemption, and that if that the project must be consistent with colors, materials, textures, things of that nature for the exterior of the building, for a consistency in the design. And number 4 is a standard requirement for repair of buildings, sidewalks, curbs, gutters, fencing, landscaping that may be damaged during the hearing. Number 5, that any expansion or modification of the facility different than what we see here will trigger another variance review, or could, depending on whether we feel that it exceeds the thresholds for what was heard here. And finally, there is a small concrete patio area out front in the 25-foot setback that we feel is inconsistent with the code, and asking for that to be removed.
Okay, can you also just go through the findings real quick?
You want to go through the findings?
Please.
Okay. So the first finding, that the strict application provisions of the ordinance would result in practical difficulties or unnecessary hardship. It was a survey of 33 single-family properties within 300 feet of the subject site, and shows that 2 properties, including this site, with a lot size less than 5,000 square feet. And the size of this legally subdivided lot places it at a land use disadvantage for equal development opportunities with 94% of the neighbors within 300 feet of the subject site. Number 2, there are exceptional circumstances or conditions applicable to the property. In addition to the smaller lot size, the smaller lot dimensions preclude full development in a similar manner as other lots For example, the average depth of lots in the neighborhood are 122.8 or 123 feet. And this particular property is 80 feet deep. So for instance, they couldn't extend their driveway and push the garage into the backyard because there's just no room because the lot depth is smaller. And number C, letter C, the granting of the variance will not be materially detrimental to the public welfare. The construction of a modest 373 square foot addition, the legalization of that without the two-car garage, staff did not feel would be detrimental to the community. The land use element allows single-family residential development similar to its neighbors. This property was subdivided earlier in the 1900s. This was obviously a lot that was a remnant lot because, as you can see by just looking at the location map up there, the vast majority of lots were larger than this. In fact, there's only a handful of these little remnant small lots. So we felt that this small addition, in which a house size of 1,300 square feet is relatively consistent with other homes in the neighborhood. It's not placing it at an unequal disadvantage in favor of the property versus its neighbors. It seems to bring it up to parity. Also, in the same condition, we noted that the addition area, neither one of them is a bedroom, which we tend to associate as adding additional parking space areas for it's a dining room, living room, and laundry room. The circulation element, the street is wider than recommended for a local street. And they have a 27-foot long driveway area, which you can park a car out front, generally on a temporary basis. The city pretty much recognizes a temporary parking of vehicles in that location. The last finding, the granting of the variance will not be contrary to the objectives of the ordinance. The R1 zone is recognized for single-family development, and the project is going to comply with the 40% floor area ratio, 40% landscaping requirement. The illegal additions will meet the setbacks, they will meet the height, they will meet the landscape requirements for the lot. So though not all the house complies with that setback, that is what was approved, at least by building permit, and has been in existence for nearly 30 years, recognized by the city with an approved building permit. The additions will meet the setbacks. The legalizing those will meet the setbacks. And that's the four that we have, sir.
All right. Thank you very much, Mr. Baxter. Well, upon review and consideration of all the materials and exhibits of the current record relative to variance case number PVAR 2009-028, located at 3352 Mary Street, and after having conducted a hearing on the matter, I am recommending approval of the variance in accordance with the findings and conditions as specified in the staff report, and with the addition of the following condition: that the landscape areas shall be maintained in good condition with live plants and free of weeds and trash. After this hearing, the decision will be prepared in writing and will be in the form of a letter sent to the applicant and all persons who responded to the public notice. So those 4 letters that staff has received, as well as myself, will also be included in the dispensing of the decision letter, and all those speaking at this hearing. And the date of the decision will be the date appearing on that letter. Under the appeal provisions of Title 30, Chapter 30.62 of the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures on the procedures from the Building and Safety section over in Permit Services, which is in room 101 of this building. This will conclude this particular item. Thank you all for coming, and it is Wednesday, the 6th of June. Thank you very much.
Yeah, go ahead. Janaz, I think he wants to give you.
This one Lieutenant Fox's Korean lady. She wants to go first, just to leave.
Well, is this the only card we have?
This lady over here first.
Okay, let me open the next case. This is case number PCUP 2007-032 at 3463 Foothill Boulevard. This is the business name is Urartu Restaurant. The business operator is Sarab Sarabian, who is also the property owner. This is a consideration of revocation of conditional use permit PCUP 2007-032 granted on April 11th, 2008 to allow the on-site sale, service, and consumption of alcoholic beverages at a full-service restaurant. Consideration of said revocation is based on the fact that the use has been operating as a banquet hall instead of a full-service restaurant with banquet facility, an expansion of the existing floor area without obtaining the required approvals, thereby violating the zoning code and conditions of approval of the CUP and the zoning use certificate. Again, at 3463 Foothill Boulevard in the C3 Commercial Service Zone, Height District 1, and the R1 Low-Density Residential Zone, Height District, should be Floor Area Ratio District 2 rather, described as a portion of Lot 2, Block K, Crescenta Cañada Tract. So I understand that there was a request for a continuance. Is a representative of the business here today? Mm-hmm. Would you like to come forward? Let's talk about that first. Hi. Did you fill out a speaker card at all?
Yes, I did. My name is Haber Minas Masihi.
Okay. So we got this request relatively recently. What's the reason for the request for a continuance?
The request for a continuance is because the attorney that is representing us could not get the reports that were filed from the police department. The police department requested them to be subpoenaed, and the attorney needs to subpoena them from the court, which we would ask for a continuance to a date where we would get those documents so we could support our case.
Okay. What's the name of the attorney?
We're using two.
What are their names?
We will have that later.
You don't have their names?
Not now.
Not now. Okay. When did you hire? What's your relationship to the business?
I work with AMAC Group, and we work with the business.
Okay. So you're the planning consultant?
Yes.
Okay. Are you the only one here from the...
And there's also Sarab Sarabian.
Okay. Does he know the name of the attorneys?
Yes, but we are still working with them, so maybe one of them will show up.
Okay. Well, here's what I'm going to do. Considering when this was scheduled and the lateness of the request, and we have a number of people here, what I'm going to do is listen to anyone that wants to speak today, and then we'll talk about a date for continuance, which would probably be next week. So, let's, if you want, you're going to speak later, or what are you planning?
I'm
to
not
do?
sure I clearly understand that, Mr. Cross.
Well, we have a lot of people here, so I'm going to listen to them, and then I'll probably continue the case after that, so that they don't have to come back.
But we will have a chance to present this case with an attorney present.
Yeah, you can come, if I continue it later, then you can have whoever you want represent you.
But as I understand, you will continue it later.
Later, right. But you should
Yes,
stick
but-
around and see what happens, although you can always look at it on tape. Was your plan to say anything today at all?
Well, other than that, we also have videotapes, and the attorney does have videotapes corresponding to the dates that the police department filed reports, and the videotapes show different compared to what the reports are.
Okay. Well, you can have those ready for next time then.
Yes, of course.
Okay. All right. So have a seat, and let's see who all wants to speak today. So let me turn to the case planner. Now, first of all, let me ask that this case, although we normally don't always coordinate with operators when it's a revocation, how long ago was this case scheduled, approximately?
About a month.
Okay. Was there any communication with the operator at that time regarding this date?
Yes, there was. I actually spoke to Mr. Sorobian directly over the telephone, and I did advise him that the meeting would be scheduled for June 2nd, today's date, and he acknowledged that it was okay, that he would be present.
Was there any communication after that, more recently, with anybody?
Yes, I've been actually also speaking to Armek Shanazarian, which Haybird actually mentioned that he works for AMAC Group,
Okay.
and he was also aware of today's date. In addition, Haybird was also aware of today's date, so we have been communicating
Okay.
and discussing the project before us today.
Okay, when was the last time that you communicated with Armic or that firm?
Yesterday, and that was because I received a letter dated May 28th and an email, and it stated that they were requesting a continuation, and that letter was submitted on Friday the 28th, I believe. That was
28th, I
on
think,
Friday.
Yeah.
And Monday was a holiday. So during that time, there was no previous mention that they needed a continuation or were going to. They never alluded to the fact that they were going to request a continuation.
Okay, well, considering that, again, that just reaffirms my desire to let whoever's here today speak, and then if they want to come back next time, that's okay too. But keep in mind, whoever's speaking, it's not going to be a debate back and forth. If whatever you need to say, if you're a member of the public for or against revocation, summarize your thoughts, and I'll take those under consideration. We also have city staff here to present some evidence. So let's start with Ms. Toledo and give us a little background as to why we're here and what staff is recommending.
Yeah, as you stated, Mr. Kraus, by the way, my name is Milka Toledo. I am the assigned case planner for this revocation. As you stated, it's a consideration of revocation based on the fact that the restaurant, Urartu Restaurant, has been operating as a banquet hall instead of a full-service restaurant with banquet facility and the expansion of floor area without obtaining the required city approvals, which therefore would violate the zoning code, conditions of the approval of the conditional use permit, and the zoning use certificate. There are several comments from city departments and members of those departments here present today to provide testimony. The Neighborhood Services section, the Glendale Police Department, do have concerns related to this establishment. There are several memorandums and correspondence that have been submitted. Some of them that I have included in this report include those dated November 19th, 2008, January 6th of 2010, March 31st, 2010, April 20th, 2010, and May 18th, 2010 is the most recent. The most recent zoning use certificate on file for this location was issued on May 27th of 2008, and that was to allow the operation of a full-service restaurant issued to Urartu Restaurant, and it was subject to a couple of conditions which are noted in your staff report. Since the establishment of the restaurant, police calls for service have increased. If you recall, the previous use was, or business was, Shakey's Restaurant. And now in 2008, or recently in 2008, is when it was called Urartu Restaurant. Therefore, obviously, Shakey's ceased operation. A new business owner took over. So since that time, or since the establishment of the restaurant, the calls for service at this location have increased significantly, and there are several code violations associated with the property and its operator. According to Neighborhood Services Inspector, there are several conditions of the conditional use permit that have been violated. And within the year and a half that this business has been in operation, the police department has noted 32 calls for service, or reported actually 32 calls for service. So therefore, both the Glendale Police Department and the Neighborhood Services section have indicated that this establishment, Urartu Restaurant, has operated as a banquet use, which violates both the CUP and the zoning use certificate. In addition, the business owner is violating, in addition to the city ordinances, several state ordinances, and that is also noted and delineated in the staff report. I would like to go over a matrix that was included in the staff report just to emphasize the conditions of approval that we are discussing here today regarding as it relates to the conditional use permit that are being violated. Condition number 1, which states that that the development shall be in substantial accord with the plan submitted in the application. A recent site visit of the property by the community planning department staff, that includes myself and Neighborhood Services inspector, revealed that a 375 square foot floor area addition was constructed at the rear of the property in the residentially zoned portion of the lot without the required city approvals. There is a former site plan pinned on the panel behind you, which was submitted originally with a parking reduction permit that was submitted in order to address the stated illegal addition. However, that application was rejected because there was no action taken by the applicant at that time to continue the process. And the case planner at that time rejected the application. There's also a photo pinned up behind you which also notes what this illegal addition looks like at the rear of the property. Conditions 2, which states that all necessary permits shall be obtained by Building and Safety Section and be in compliance with the Glendale Building Code and all other applicable regulations. Again, we can refer to the violation I just stated. In addition to the building permit, a new use variance, conditional use permit, and parking reduction permit would be required. The applicant failed to file all the necessary applications. Condition number 3, that states that all necessary licenses and required from the federal, state, county, and city authorities, including city clerk, shall be obtained and be kept current at all times. No live entertainment permit has been issued by the city clerk. Also, the ABC license contains the following condition that the police department states have been violated. That includes that live entertainment provided shall be limited to a musician trio with non-amplified instruments. No noise from said entertainment shall be heard beyond 20 feet from the exterior of the premises in any direction. That there shall be no amplified music on the premises at any time, and a single jukebox or stereo may be maintained upon the premises. However, the music shall not be audible outside the premises. Condition number 5 states that the facility should not be rented, leased, or otherwise occupied for purposes not specified in this application, meaning the conditional use permit application. Both the Glendale Police Department and Neighborhood Services have indicated that this establishment has operated as a banquet hall and noted that private parties at this facility occupy 100% of the floor area service area. Also, the ABC license condition that the premises shall be maintained as a bona fide food restaurant and shall provide a menu containing an assortment of foods normally offered in such restaurants. Condition 6 states that any expansion or modification of the facility shall require new conditional use permit. Expansion shall constitute adding of any additional unit, floor area, increased hours of operation, or any physical change as determined by the planning hearing officer. As I alluded to earlier, an illegal 375 square foot floor area addition was constructed at the rear of the property in the residentially zoned portion of the lot without the required city approvals. New approvals from the Community Planning Department, as mentioned in condition number 2, were never obtained. Condition 7, which states that all music, lighting, noise, and odors shall be confined to the occupancy as to not disturb occupants of other businesses or properties and patrons on public right-of-way. The police department has recorded 32 disturbance complaint calls for service at this location since the business was established. The nature of the calls have been primarily for noise as a result of amplified music, patrons loitering outdoors, and fights. The most recent call for service took place on March 27, 2010, which included amplified music heard 100 feet away from the facility by the officer, approximately 20 to 30 people smoking outside near the main entrance, designated as a non-smoking area, which therefore violates the city's fresh air ordinance, fighting, valet parking on other lots without permission, occupied in the shopping center across the street, and the disc jockey refused to shut off music, and the owner created a drunken disturbance. Condition 14 states in part that all noise shall be contained on the site to such that patron or persons of normal sensitivity off-site are not disturbed. Again, we can refer back to condition number 7.
Right.
And lastly, condition number 18 states that sufficient measures be enforced to effectively eliminate interior or exterior loitering, parking congestion, disturbing noise, disturbing light, loud conversations, and criminal activities. Again, the operator/business owner continues to violate the conditional use permit, ABC license, and disregard notices by the neighborhood services inspector to address their violations. And we can again refer to conditions 7 and 14. The business owner has not made any serious attempt to address the conditions noted and the violations. This established, therefore, constitutes a nuisance to the neighborhood and the community, and that is what has been determined by city staff. And therefore, based on those facts noted and documentation submitted by these departments, again, Neighborhood Services and the Police Department, and the Neighborhood Services Inspector, again, staff recommends that the Planning Hearing Officer revoke their conditional use permit, and that would be PCUP 207-032. And included in that were the findings as to why this permit should be revoked. If you have any further questions, I'm available to answer them.
Okay, thank you. I know we have representatives from Neighborhood Services and Police, so knowing that we're probably going to hear more from the operator later, did you want to say something today, or did you want to save it for next time, or just be available for questions or to clarify something? A, B, or C? Okay. Again, if you hear something, the next hearing, you can always come back and comment.
Mr. Administrator, Lieutenant Bruce Fox, the Glendale Police Department.
Thanks.
ABC Compliance Unit. I brought various people with me because they all have individual incidences which they could testify to.
Okay.
I can make them available at future hearings or available for questions. It's pretty much up to you, sir, whatever you want.
Well, again, as long as they're available, and this isn't going to cause problems with them coming back, I'll just leave it up to you then.
Okay.
You want to do it next time?
Yeah, let's hold them because a lot of it might be in rebuttal to testimony that you might receive prior to that.
Because we do have your information in the file,
Yes,
so hopefully it'll just be clarifying details.
Yes, sir.
All right, so if that's okay, then we'll wait till next time for that.
Thank you, sir.
Mr. Brownell, do you want to wait too, or? Hi.
Good morning, Mr. Krause. Thomas Solo, Neighborhood Services Inspector. We also concur with the Glendale Police Department, and we will hold and come back.
Okay. All right. So let me ask, before we hear from members of the public, Mr. Masihi, did you want to say anything now, or were you going to pretty much save everything for the next time? Just give me a thumbs up or thumbs down.
Next time. The only reason we...
Well, If you want to say just yes or no, otherwise you have to come forward and I'll let you, if there's something you want to explain, I'll let you do that now. Okay.
The only reason, Mr. Cross, that we requested the continuance so late is because we assumed that the police department would have the public records available to the public. We didn't assume that they would request a subpoena by the court.
Okay.
That's why
All right.
we requested it so late. But
Okay,
we will
thanks.
save everything for
Okay.
next hearing.
All right. Lieutenant Fox?
Sorry, I meant to mention this earlier. I just wanted to let you know that the first time the police department became aware of this public records request or request for calls for service was last Friday, May 28th.
Okay. Does anybody else from the city staff want to say anything at this time? Okay. So, we've got a couple of other cards. Shelley, is it on? Okay, go on forward. And again, I guess you haven't heard the whole story. You haven't heard the operator's side of it, but there's something you want to present now as to whether or not you think this case should be revoked or not, then let me know.
Real quick, I'm with the police department. I'm Detective Prokash with the police department.
Are you going to translate?
If that's
necessary?
Okay. That's
Okay.
fine. It's okay with you.
All right.
이렇게 드려요?
네.
그냥 말씀하시면 돼요. She needs a full translation. So when she speaks, I'll translate.
Okay, sure.
안녕하세요. 저는 4513에 사는 켈리안이라고 합니다.
Hi, I live at 4513. My name is Shelly Ann.
4513
413 어디?
4513 프레드릭.
Frederick? Okay.
네,
Alright.
저는 그곳에서 1991년 1월부터 지금 현재까지 20여 년을 살고 있는 주민인데요.
I lived there since 1991, approximately 20 years.
1년 전에 새로운 식당이 오픈하게 되면서 저는 저녁이면은 잠을 좀 잘 수가 없어요. 제가 10시 반에서 11시경에 잠을 자는데 음악 소리가 너무 많이 커서 동네 새로운 나이트 클럽이 생긴 것 같은 생각이 듭니다.
Approximately 1 year ago, a new restaurant opened up down the street, and ever since then, I haven't been able to sleep at night. I go to bed around 10 or 11 p.m. at night, and due to the loud music and the noise coming from the restaurant, I haven't been able to sleep. It appears as though a new nightclub has opened up in the town.
이 식당이 있기 전에 케이키 피자라는 식당이 있을 적에는 제가 살면서 뭐 불편한 느낌을 전혀 받지를 않았는데 이제 새로운 식당이 들어오면서 주로 주말이면은 밤늦게까지 12시 때로는 12시가 넘게까지 굉장히 큰 음악 소리를 들리게 해놓기 때문에 저는 5시 반이면은 일어나서 일을 갈 준비를 하는데 잠을 잘 수가 없어요.
Prior to the new restaurant being open, there was Shakey's at that location, and I hadn't had any problems with Shakey's as far as noise is concerned. However, with the opening of the new restaurant, it has been a big problem for me trying to get sleep. I have to wake up in the morning at 5:30 to go to work, and on the weekends, it's just that the noise continues on after midnight, so it's really difficult for me to get any sleep.
Do you know, can you ask if the noise is mostly from, is it just music? What kind of music? Is it people outside, people inside?
저녁에 나는 거기 식당에서 나는 소리가 음악 소리예요? 아니면
음악
사람들?
소리인데 주로 댄싱 뮤직을 많이 틀어놔서 굉장히 이렇게 울림이 커요. 저희 방하고 그 집하고의 가까운 거리.
Mostly it's a dance music. There's a lot of bass involved, so there's a lot of vibrations from
the bass.
Yes.
Okay.
근데 그 앞집의 비즈니스가 매우 중요하다고 저는 생각하기 때문에 굉장히 많이 참고 기다리다가 12시가 넘었을 경우에 제가 경찰에 신고를 한 적이 여러 번 있는데 어떤 경우에는 경찰에 신고를 하면은 경찰이 오기 직전에 어떻게 앓은 것처럼 다 모두 스탑이 되는 경우도 있었어요.
I believe that business itself is important to exist. So I've not called the police too often, but I've waited until the music was loud late at night. And at times when I called the police, I've seen cases where they would turn off the music right before the police would arrive, almost as if they knew that police was going to show up.
네. 근데 이제 저희 집하고 저희 안방하고 그 집의 그 식당에 담 관계가 예전에 세기 피자였을 때는 한 10m, 제가 눈으로 봤을 적에 한 10m의 거리가 있었는데 요 근간에 이 집이 새로 오고서는 새로운 건물을 건축을 해서 저희 안방 창문하고 그 집 식당의 부엌하고의 거리가 제 눈으로 봤을 적에 5m에서 6m 정도밖에 되지를 않아요. 그래서 그 부엌문을 열어놨을 적에 그릇을 던지고 뭐 얘기를 하고 담배를 피면서 거기 일하시는 분들이 얘기를 하든지 주차장 가까이에서 떠들 적에 저희 안방문을 열어놓으면은 그 소음이 굉장히 커요. 그래서 잠을 잘 수가 없는 그런 지금 환경이 돼 있고, 또 하나는 그분들이 나와서 담배를 필 적에 저희 담하고 그 집의 식당에 그 가건물을 지어놓은 건물이 굉장히 그 펜스가 거의 가까이 와 있어요 지금. 근데 담배를 피다가 담배불을 잘못 놨을 경우에 그 옆에 있는 이런 잔디나 이런데 불이 붙었을 때 저희 집을 시작해서 저희 집에 있는 그 콘도미니엄이 다 연결이 돼 있기 때문에 불이 날 수 있는 그런 위험도 저는 상당히 느끼고 있어요 지금.
Thought I saw the universal sign for smoking there. Yeah.
She mentioned that in the past when Shaky was there at that lot, there was when she estimated it was approximately 10 meters, that was a distance between the Shaky's restaurant and her bedroom window. And now with the new restaurant, the kitchen open window, the kitchen window of the new restaurant and her bedroom only is 5 to 6 meters. That's her estimation.
That's it?
That's
got to be more than that.
저기 건물에서 뒤에 나무가 가려 있죠? 그 나무 바로 뒤가 저희 집이에요.
If you look at the picture, the behind the
Is that
building,
the
there's a
illegal
tree.
addition, you think?
That's what she's saying.
She's referring to?
The addition,
Okay.
yes. She says if you look at the picture, right behind the business, there's a trees.
Right.
Behind the trees is her house or her.
So she's right just immediately north on Frederick.
Yes. Correct.
Okay.
And she says because of that distance and the new addition, she says that whenever the people are in the kitchen washing dishes or talking, the noise travels real easily to her bedroom window. And when people from the restaurant are back there smoking, she's worried that if they don't put out their cigarettes correctly, that it could cause a fire, and she would be the first house to be affected by the fire.
Who's doing the smoking? Are these employees or patrons or both?
거기에 일하는 엠플로이도 있고 또 경우에 따라는 그 주차장에 손님으로 오신 분인지 그거는 제가 모르겠어요. 거기서 담배를 피는 경우도 많이 있어요.
Probably both.
Both? Okay. Thank you. Anything else?
그래서 저는 이렇게 많은 우리 시민들이 컴플레인을 하면은 그 식당에서 음악을 트는 거를 조금 뭐 방음 장치를 한다든지 이런 그런 주민을 위해서 조금 협조해 주시는 그런 게 있기를 바랬는데 여지까지 1년 가까이 그런 경우가 너무 없어요. 그러다 보니까 제가 오늘 일도 못하고 여기까지 왔는데 좀 시민을 우리 더 보호해 주는 그런 행정을 좀 해주셨으면 대단히 감사하다고 생각합니다.
I thought that if the residents of the nearby, residents that reside near the restaurant, if they complained, that the people at the restaurant would do something about the noise, as far as putting soundproof walls, whatnot, or lowering the music. But for over a year, that they have not complied with lowering the music. So today, that I had to miss work and come here to present my case. So I hope something gets done to appease the residents.
Can you ask what days of the week is it noisy?
언제 음악이
주로
제일
금요일, sometime 금요일도 있고 토요일, 일요일
Friday.
많죠.
So, the time's Friday, but mainly Saturday, Sunday.
Is the business ever open any other day?
그 가게는 딴 때는 문 열어요?
제가 볼 때에 문은 오픈한다고 돼 있는데 영업은 주로 주말에 거의 하는 것 같아요. 주말을 하는 영업은 거의가 파티를 하기 위한 어떤 그런 모임인 것처럼 제가 보기에 느껴져요.
She says they advertise or that they're open during the weekdays, but what she's seeing is that they only do business over the weekend, and the business that they do is usually just private parties.
Okay. All right, thank you.
Thank you.
Thank you.
Yes, sir.
Okay, I have one more card, and if you want to speak today and you haven't filled out one of these cards, please do so. Antonio Rodriguez.
Good morning. My name is Antonio Rodriguez. I live at 4515 Frederick Avenue. I'm basically west of 4513, which is north of Urartu Restaurant. You see that angled parking on the west side of the restaurant? My property is to the north of that. Okay? Ever since Urartu Restaurants opened up way back in, I believe it was June, probably April, March of 2008. We were really excited because there's a restaurant coming in, okay, and we saw that as a good thing for our property values to stay stable. Well, little did we know that this restaurant was not a restaurant. They started having all these banquet parties all the time, and sometimes every day of the week. And we've called them various times to complain about the music. In some occasions, they've been very cooperative. They lowered the music down. On other occasions, they've been very rude, uncooperative. We've had to call the city, the police department, to complain about them. We've contacted neighborhood services about their illegal structure. I'm an architect by profession, so I knew when that was going on that was illegal. I reviewed and verified the zoning code, and they're not supposed to build anything there, so it's illegal. So they've done that. Ever since they've been there, they've been a nuisance. Loud music, loud talking, smoking. Sometimes when their parties end, there's been some cars speeding from their driveways onto Foothill Boulevard, and they've actually been a nuisance. They haven't kept the property clean. Okay, that entrance from Foothill, that's Frederick Boulevard. On their east side, they have planters, and also on the west side where the channel is at, they've never trimmed and cleaned those areas. Before, when it was vacant, it was cleaner than it is now, and it's occupied at this point. And we've called the police various times, and we've gotten to the point where we've just gotten sick and tired of them. They're actually not a very good neighbor. We were hoping that they would be, but they just don't want to cooperate. And according to ABC, the music is not supposed to be audible 20 feet from their premises. And Mrs. Ann House is probably around 25 feet from the existing building. before the addition. And my house is probably like around 35 feet. Well, sometimes you can hear that music further than that, probably 100, 125 feet away. And they know they're not supposed to have any live entertainment and any things like that. And then, but we were able to get this.
Can you leave that for the record?
Of course I can.
All right, thanks.
I have an electronic copy of this, so yes, you
You
can
could give
have
that to Ms. Toledo then before you leave.
before I leave. Yeah, and we just gotten to the point where they haven't been very good neighbors. We were hoping that they would be, and we were hoping that they would stabilize our neighborhood and so forth, and keep our property values up. But with this kind of a business, if I were to sell my house, how would I actually find a buyer? And especially with the real estate disclosure laws, how can I tell them, oh, don't worry, this is a nice house. Oh, by the way, this restaurant hosts all these banquet parties. I wouldn't be able to sell it.
Do you know when that addition was built, approximately?
Probably about 6 to 9 months after they opened. And at that point, I started doing my research into the zoning code. And I was able to determine what zone they're in and the zone that we're in and what impact they were supposed to be and how far away they had to be. And not only that, but they built the addition onto the retaining wall that's part of the residential.
Retaining wall that was there before. Okay.
The retaining wall was part of the residential complex that was done there. So the retaining wall is on the other side of the property line. So that's a fire hazard in itself.
Okay.
Okay.
All right. Thank you.
You're welcome.
All right. I don't have any other cards. Seeing no one else today. Lieutenant Fox.
I just wanted to update you, sir, if I could,
Okay,
on some
sure.
things that weren't in the staff report.
Okay.
Since the time of the staff report, there's been 4 additional calls for service to the police department for noise complaints at the location. And I recently just became aware of the owner was arrested / cited on February 13th, 2010 by the Department of Alcohol Beverage Control for serving distilled spirits in the location, and I believe he has a court date pending on that. And I just became aware of that yesterday and want to add that to the staff report as well, sir.
And they don't have a license for that?
No, they have a Type 41 for beer and wine only.
Beer and wine only.
Yes, sir.
At a full-service restaurant?
Yes, sir.
One of those? Okay. And these 4 additional calls for service due to noise have been since approximately when? You know?
I believe the last one in the staff report was March 27th. We've had 4 since then. They were all in May, as a matter of fact.
Okay. All right. Okay, so that's probably since this hearing was scheduled.
Yes, sir.
Okay. All right, thank you.
You're welcome.
So then, what I'm going to do is continue this case till next week, and hopefully everybody will be ready then. So, I'm going to continue the consideration of revocation of conditional use permit PCUP 2007-032 to June the 9th without further public notice. And that concludes today's
Mr.
hearing.
Cross.
Oh, Mr. Foy, did you have something
Yeah, just
to add?
for a point of clarification for the people who are here, will they be able to speak again after hearing the presentation by the owner?
We'll just have new people speak, because it's not going to be a debate back and forth. I mentioned that earlier. So if you were here but didn't speak, you can speak next time. Okay? All right. So again, that closes this case, and we are adjourned for today. Thank you for coming.